Let's bring in CNBC contributor Jonathan Kanter. He's the former Assistant Attorney General for the Antitrust Division of the United States. He joins us on the fast line. He, by the way, is part of the team that brought this case. Jonathan, great to have you on a day like today.
Thanks for having me. Nice to be with you.
Are you surprised that the most severe of the remedies was taken off the table effectively?
Well, it's hard to get surprised in this business. I think you wait anxiously and want to see what the court says, and it's a mixed bag. I think on some aspects, the most extreme remedies, as Eamon said, like a divestiture of Chrome, is now off the table, at least pending appeal, and that is without a doubt a victory for Google. There are other areas, like the inclusion of AI as part of the restriction, the inability of Google to make its AI the search default in places like Android, Chrome, and Apple and others, which includes both search and Gen AI, is certainly a win for the government. And also, significantly, that Google has to disclose aspects of its search engine, index, and data. And the reason this is significant is because the idea behind the remedy is to allow Gen AI companies who have chatbots who also want to deliver search results to bootstrap search Gen AI, search to chatbots to try to deliver a combined experience and take on Google. And so if you're thinking about the perplexities and their ilk, this is probably a good outcome for them.
A lot has changed since this case was first brought, Jonathan. I'm wondering how that landscape has changed and whether or not a case like this could be brought again in the sense that now, Chrome is not where it's at. It's all about Gen AI, as you mentioned, and how the case might have been differently pursued, and if a case like this could be brought in the age of AI.
I guess I would disagree with the premise there. Browsers are going to be the feeder for the next battle of AI. It's one of the reasons why a lot of the AI companies like OpenAI and Perplexity and others are investing in developing browsers because they view that as important to displaying results. It is a modern version of browsers going to be extremely important in the context of AI. So, yes. Also, I think one of the things that we learned from the Microsoft case is that times of change and transition, when we're seeing new technologies emerge, are often when the remedies are most important. So if you go back to the Microsoft antitrust case, which is really what led to the birth of Google, Amazon, Facebook, and others, there was a lot of disappointment that the remedy didn't go full breakup. But ultimately, the remedy in that case allowed companies like Google, browsers like Chrome, and others to come to fruition. So we'll have to dig into this remedy, but there's a hope that this case and more like it against big tech will create opportunities for smaller tech companies who are innovating to find pathways into the market to compete.
Mr. Kanter, it's Karen Feinerman. Thanks for being on such short notice. So you said this is the remedy pending appeal. What do you see as the most likely reason, or what would you put forth as most likely argument to appeal, and how do you think that would be? How do you think that would play out?
So we'll have to see. I mean, there is a high likelihood that Google itself will appeal. I think they're dealing with a liability decision that found them to be a monopolist and a legal monopolist in search. There are numerous remedies in here that clearly will make it harder for Google relating to AI, relating to distribution of its products and services, and the inability to have exclusives. So the likelihood is high that Google will appeal. It is also possible that even if the DOJ is satisfied with some aspects of this remedy, it might argue that that the court's opinion didn't go far enough in ordering things like divestiture or absolute ban on payments. And so it is conceivable the DOJ will cross appeal. So I think there are a few more rounds left before we know the final outcome of this case.
This case is partially brought, and correct me if I'm wrong, to preserve the competitive landscape, to make sure that big tech doesn't monopolize innovation. And yet, in this time when this case is being heard, we've come up with a crop of brand new competitors out there: Perplexity, OpenAI. Just today, Anthropic got a $183 billion valuation. And I'm just wondering how you view that, in the context of the importance of this case and whether or not it was needed to preserve a competitive landscape that seemed to thrive despite the case going on.
Well, I think the idea is that first of all, if you look at the data, while those companies are very promising, they haven't really made a dent in Google's search business, and certainly not in Google's search advertising business. And so it is still by far the super dominant firm in both of those spaces. Second, they have promising technologies, not unlike the way browsers and other companies did back in the day of Microsoft. And so the whole concept behind the remedy is to make sure that all this great innovation that we're seeing in the marketplace has the opportunity to succeed, because otherwise, at a moment like this, a monopolist, in this case Google, would have the greatest incentive to tighten the screws and find ways to keep those competitors out of the market through anti-competitive conduct. So the hope is that with the remedy like this, with the case having been brought, we will have the opportunity to see this inflection point and these new competitors reach their full competitive potential in a free market rather than one that's been closed off by the conduct of the dominant firm.
Jonathan, Tim Seymour, again, it's great to have you tonight. So thanks for being here, because your perspective is certainly unique from the legal community. And I guess forcing Google to share data. This, to me, seems also a big headline that might get lost, and that this is a big win for Google. What do you think about that? And what do you think about how that has implications for the other 3 or 4 giants who live off their data?
I think it's quite significant. So Google, during the remedies proceeding, had argued that a divestiture, that sharing of data was the equivalent of a divestiture. So I guess by Google's own definition, they do have to divest something here, which is their data. I think from a strategic perspective, the reason this is important is it gives some of these AI companies who have LLMs with search-like features the ability to bootstrap search data in order to make themselves more of a full-throated and full-stack competitor to Google. So the hope is that it will create more robust competition up and down for the entire search stack if LLMs can get access to Google search data, close some of the scale advantage that has made it difficult for them to replicate Google's web search capability, and then offer, a meaningful competitive alternative.
Does this have any implications on some of the other cases against big tech, antitrust cases against big tech?
Yes and no. So I think this certainly will be relevant in terms of precedent for some of the antitrust cases if the government or if the plaintiffs win. Remember, Google lost in a pretty big way on the underlying case, both here and in a companion case brought in Virginia by the Department of Justice on its advertising technology, and we're still waiting for remedies there. So the question is really, yes, this will matter in terms of helping give some guidance to courts as to where remedies could go, but is hardly definitive on liability. And if you read the decision, it maintains the opportunity for the court, if the remedy's not working, to crack it back open and tighten the screws. So, for example, the judge in the decision said that while he's not banning Google from paying companies like Apple or others an amount of money to distribute their search, he's open to doing so if the remedy doesn't succeed. So we could certainly see changes going forward here as well. And so it's instructive, but it's not definitive as to the other cases.